pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we have a public comment period here. Is there any member of the general public who wants to speak on something which is not on our agenda today? I don't see anybody, so we'll move on. The next item is the consent calendar. First of all, we have the approval of minutes. Oh, okay. The green light was on. Okay, all right. Okay. The approval of minutes for the September 6th meeting. I was there and Pete was there. Bob was not. So do you have any comments on the minutes, Pete?
No, I make a motion that we approve the minutes of the meeting of September 6th.
I'll second that. Call for a vote. All in favor say aye.
Aye.
Aye. All opposed? The minutes are approved. Okay. We have also on the consent calendar acknowledgement of notice of withdrawal for 4 items for Herman William Schlew Jr., 17S006 through 17S009. Anybody have any comments on those withdrawals? Well, let me ask Mr. Austin, is that, you got any comment on it?
Yeah, Mike Austin for the Madera County Assessor's Office. In regards to William Sloop, we originally added a building to his assessment because we learned that his son-in-law passed away who owned the building, did not own the land. And so, huh?
I didn't say anything.
Okay. And so we had to add the value to his property value, and he came in and I suggested for him to file an appeal if he disagreed with the value. Well, in the meantime, he got an appraisal, and we talked to him, and I went over all the values, how we come up with a value, and he decided to withdraw, I think about a month ago.
Mm-hmm.
So, accept the withdrawals.
Okay.
Thank you.
Okay. Any comments from the board? No. The motion?
I move that we approve or acknowledge the withdrawal as stated.
I second it.
Okay, we have a motion and a second to acknowledge the 4 withdrawals. Call for a vote. All those in favor say aye. Aye. All opposed? Motion passes. Okay. All right. We need to do a swearing in of all parties and witnesses in attendance to provide testimony. Sarah, I think you usually swear them in. Do we have some people who are going to be testifying today before the board need to be sworn in? Is a gentleman, if you're going to be testifying in front of the board, you need to be sworn in.
It's my understanding he's legal counsel. I may be wrong.
Okay.
Do all parties in attendance solemnly swear or affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, our first hearing is 3906, hearing for Central Valley Concrete and John R. Lawson Rock and Oil, Inc., 17S001. Hey, you're here for that? Okay.
Mike Austin for the Madera County Assessor's Office. And I'll give you a little background in regards to this. We assessed this airplane on an escape assessment.
Okay, can I just give you 1 second? I check with the attorney. According to our protocol, which one of these should we hear first?
Well, what's the assessor's position on who bears the burden on this?
That's what I was getting to. The assessor's office has the burden of proof because we did do an escape assessment. So we had the burden of proof, and that's what I was going to let everybody
Okay,
know.
all right. I just wanted to make sure we
Hey, no problem.
didn't get it backwards.
Okay. We have staff from our office here today that's going to actually do the presentation. And we have our county counsel here because the taxpayer has requested findings of fact. And so we have county counsel here to help write the findings of fact. And then that's why he's here, and they can introduce themselves before we get started.
Good morning, members of the board. Mike Linden, Deputy County Counsel.
Good morning, member of the board. And I'm going to do my presentation at this moment and introduce myself at the same time.
Okay.
My name is Tran Cooper, COOPER. I work in the Madera County Assessor's Office as the supervising auditor appraiser. I've been working in this capacity for approximately 4 years. I have worked in the Assessor's Office environment for over 20 years. I've obtained my appraiser certificate in March of 2099. I earned my advanced certificate in November of 2002. The subject property is a 2002 CL 604 Challenger Bombardier that was purchased and moved to Madera County on or around August 11, 2016. And if you'd like to see the exhibit, it's under Exhibit 8 of the Assessor's Exhibit.
Does everyone have the exhibit?
Okay.
Okay, and the Exhibit A, if you look at the box to the right-hand corner, almost in the middle of the page, it said they moved to this county is August 11, 2016. Is it okay for me to move on?
Yeah.
Okay, thank you.
Yeah.
As with other taxable personal property, such as boats, business personal property, and trade fixtures, the property is valued each year at market value. The Assessor's Handbook, Sections 577, Assessment of General Aircraft, recommends that the assessors consider the three primary approaches to value: cost, comparable sales, and income when determining the market value of an aircraft. Specifically, the aircraft value being contested was arrived at by using the comparable sales approach, as the purchase date of August 11, 2016 was reasonably close to the 2007 lien date. For property tax purposes, there are two classifications of aircraft: certified aircraft generally used in the transportations of passenger or freight for hire, and general aircraft or aircraft not certified. The subject aircraft is considered a general aviation aircraft, as the applicant does not possess the appropriate certificate or permit issued by the Civil Aeronautics Board of the United States or its successors, or the certificate permit issued by the California Public Utilities Commission or its successor, authorizing such air carrier to engage in such transportation. Accordingly, for property tax purposes, the subject aircraft is valued as general aviation aircraft at the consumer level. Similar aircraft based in Madera County are valued in similar manner. The assessed values for these aircraft also include a component for sales tax in the assessed value. Property tax rule 10B requires that, and I quote, if the cost approach is employed, the cost shall include the full economic cost of replacing the property tax in service. Full economic cost includes costs typically incurred in bringing the property to finished state, including labor and material, freight or shipping costs, installation costs, sale or use taxes, unquote. The inclusion of sales tax as a component of full economic cost is fully further supported by Revenue and Taxation Code, Section 110, footnote, Xerox Court versus Orange County, 1977, 66 Cal App 3D 746, which is cited under market value concept, where price is the basic of value. The sales tax and freight charges are elements of value, unquote. Accordingly, the assessors 2017-2018 of the subject general aviation aircraft include a component of sales tax. The assessor's office issued an escape assessment for 2017 based on the information supplied by the property owner on the standard annual aircraft property statement received on August 14, 2017. Using the aircraft Blue Book price digest to value the aircraft as directed by the California State Board of Equalization and the Assessor Handbook 577, a value of $6,447,186. And if you could turn your attention to Exhibit C, the calculations for the value is there. I can walk you through if you would like. Are you all at Exhibit C?
Yeah. Would you like her to walk you through the calculation?
Yes, please.
Yeah, yeah.
As of the 2000,
Pardon?
okay, I'll just wait for Mr. Meany if am I ready to go?
Yes.
Go ahead. Yeah.
Thank you. As of 1/1/2017 lien date, the retail value based on the Blue Book is $5.8 million for this subject aircraft. We deducted 10% from the State Board of Equalization's guideline. Then we add the sales tax of 8%. That amount is $407,600. And in addition to that, we adjust for the low airframe because it has low hours. Then we apply a 10% penalty for late filing, and I'm going to go into that at my next testimony. Resulted in the $6,447,186 in assessed value.
Go ahead and ask her about that.
Yes, on the late penalty, the 10% late penalty,
Yes.
is that assessed to all airplanes, or?
The late penalty is because the statement was not returned in a timely manner. We have the state board has a deadline of May 7 of each lien date for the statement to be returned. Anything postmarked after May 7 is subject to a penalty under Section 463. So it's not all airplane that has a penalty, only late airplane would have a penalty
Okay,
applied
and
to it.
you're adding that to the value of the
That's
plane?
correct, yes. Is that okay if I can move on, or
Yeah,
you
we have
you
any more questions?
questions?
No.
Okay,
We have no more questions. Go ahead.
all right, thank you. This amount, 6,447,186, which include a sales tax component. The escape assessment also includes a 10% penalty to the value pursuant to Revenue and Taxation Code 463 due to late filing. And if you could just go to Exhibit B. Are we at Exhibit B, sir? That's the postmark. It has to be postmarked by May 7th, not to have a penalty. For an assessment not to have a penalty, it has to be postmarked by the post office by May 7. In this case, the subject property has a postmark on the envelope of August 11, 2017. Subsequent to receiving the 2017 tax bill, the property owner provided the assessor's office staff with additional documentation, which did not result in any adjustment to the enrolled value. As a result, the property owner filed an assessment appeal application with the Assessment Appeals Board clerk. The assessor has since agreed to use the purchase price of $4.95 million as the basic for assessment purposes. However, the applicant did not accept that sales tax as a component of cost, and penalty should be added to the assessed value. In response to the assessment appeal application submitted by the property owner attorney, I contacted Mr. Lawson's office and was directed to discuss the matter with Mr. Troy Ewell, the property owner's attorney. I explained to Mr. Ewell that sales tax is a component of cost and a 10% penalty is required pursuant to the Revenue and Taxation Code 463. Mr. Ewell verbally agreed to the set's requirement. I follow up with an email where Mr. Ewell asked me to supply the documentation of legal basics on which their assertions was predicated, which I did. Mr. Ewell responded with a letter agreeing to the penalty being applied, but not the sales tax component being added to the cost, citing CKE court case as well organized exhibit regarding the purchase of the aircraft. The review of the information by the assessor's staff found that the taxpayer did not have a factual basis for exclusions of the sales tax component included in the assessed value. The applicant was not a certified carrier or air taxi, but in fact a general aviation aircraft and administrative direction promulgated by the SBE with respect to the requirement of the assessed value of general aviation aircraft must include a component of value equivalent to what sales tax would have it been paid. Using the agreed upon purchase price, we respectfully request that the board upholds the revised value of $5,880,600. The revised value includes $960,000 in sales tax and $534,600 in penalty. The assessor's office respectfully requests that the board accept and uphold the revised value because adding sales tax as a component of cost is supported by Revenue and Taxation Code annotation 100.0050, which states that sales tax is a value component regardless if exempted under sales and use tax law. Second, Revenue and Taxation Code Sections 110 footnotes judicially case Xerox versus Orange County, where sales tax is an element of value regardless if it is actually paid or not. And then Rule 10, which states that if cost approach is employed, it should be at full economic cost, which is at the consumer, including sales tax for general aircraft. And as according with Assessor's Handbook 577, Assessor Handbook 587, and Assessor's Handbook 504. All similar properties in Madera are valued with sales tax as a component of cost, equalizing the role for this type of property. The applicant has not overcome the burden of proof by producing a basic that is supported by the statute for why sales tax should not be included in the property tax assessment. I thank you for your time. If you have any question, I would like to answer them at this time.
Question?
No.
No? Okay.
Thank you.
Okay. Does that conclude the assessors?
That concludes my presentation.
Mike, is that, anybody else going to speak?
Yeah, Mike Austin, basically, just want to reiterate the regulations. First, R&T Code Section 441 is a regulation that the taxpayer shall send us a business property statement even if we do not send them one. That's codified in law. The Section 110 of the code also basically says that if we use the cost, then we shall add sales tax and other components of a value to the finished state, whether it be freight, whether it be other things. And we do assess all of these the same way to everybody in this county. We have for years, as long as I know we've been doing them. The only other thing I'd like to add also is on our third book, basically we do have a way to value the property, and it's 100-0050. It says valuation. I believe Trang Cooper has already said that, but I want to reiterate this. For property tax purpose, if sales tax, use tax is applicable to similar consumers, which is consumers at the consumer level, which is retail, use an aircraft at similar trade level, which is Rule 10, or Rule 10 of the California Code of Regulations. Sales tax is to be included in the assessment. And basically, we want to reiterate that, we add sales tax to everyone's aircraft in the county. Okay. That concludes. Mike, do you have anything to add?
I think all the relevant legal authority has been set forth by Ms. Cooper and Mr. Austin. I have nothing further to add at this time. I may have something to say after the applicant's presentation.
We have a representative of the Lawson.
Yes, good morning. Julio Sanchez, here on behalf of John R. Lawson, Rock and Oil, and Central Valley Concrete, Inc. As the assessor's office has noted, the main issue to discuss is the sales tax issue. We did engage in conversations as to the market value of the plane and such, and we did reach an agreement as to the purchase price being a basis for the valuation, given that John R. Lawson, Rock and Oil, and Central Valley purchased the plane about a year before the assessment, and there was about a $2 million difference between the escaped assessment and the purchase price, the escape assessment being higher, and typically property tends to decrease in value. And so there was an agreement as to that. The issue that remains is the sales tax issue, and upon requesting authority from, legal authority from the assessor's office to see what the basis was for including the sales tax, we did receive the Xerox case that the assessor's office mentioned, along with the other authority that they've cited. And while the Xerox case does apply sales tax, that case had to do with the leasing of copy machines, not aircraft. And also in that case, while it went down and analyzed the valuation methods, as the assessor's office has mentioned, the market value and the cost approach, and included sales tax there, before it analyzed those methods, it talked about the trade levels and how property should be assessed at its proper trade level. And so then a couple years after, or a few years after the Xerox case, which I believe is in 77, in 2008, the court came out with the Arbach v. Assessment Appeals Board No. 2 for County of Los Angeles case, which talked about aircraft valuation and talked about the application of sales tax to aircraft. There, it mentioned Xerox, and that Xerox stands for the proposition that property should be valued at its appropriate trade level. Then Arbach went on and said that in that case, there was a common carrier, and because other similarly situated purchasers of that aircraft would fall under a sales tax exemption, they would meaning they would not pay sales tax on purchase of the aircraft, then sales tax could not be included in the valuation of that carrier. The basis for that was the trade level, but even delving deeper into that, basis as to why trade levels are treated differently is because similarly situated purchasers would not incur that sales tax. The aircraft that John R. Lawson and Concrete Valley Oil purchased, Concrete Valley or Central Valley Concrete purchased, they purchased without paying any sales tax. They purchased it subject to a codified sales tax exemption, which I believe is Section 1620 of Title 18 of the California Code of Regulations, which basically states that if pursuant to the purchase agreement and then in actual practice, the aircraft is delivered to a point outside the state of California, there is no sales tax incurred. That happened in this case, and it happens a lot. Similarly situated purchasers who purchase aircraft and take delivery outside the state do not incur sales tax. So under the market approach as analyzed by Xerox, in which they indicate that sales tax is part of the price. Sales tax in this case is not part of the price. It's not tacked onto the price. It's not, for example, as if you go to the store and you purchase a bag of chips for $1.99, and then you get sales tax added onto that, and that sales tax is added to that bag of chips. It wasn't added on to the price of the aircraft. Under the cost valuation, which Xerox also talks about, and Xerox, they add sales tax. On the cost valuation, there would be no costs incurred in purchasing. The sales tax would not be part of the costs incurred in purchasing the aircraft, because under that tax inception, sales tax is not paid. So pursuant to that codified sales tax exemption, John R. Lawson did not pay any sales tax. Now, as stated in the Arbach case, when you have similarly situated purchasers, as the court explained, were common carriers in that case, and in this case are other purchasers who take delivery of aircraft outside of the state of California, they would never incur sales tax in that transaction, and because sales tax is never included in that transaction, it does not come into play for valuation purposes. For that reason, we believe that sales tax should not be included in the valuation of the aircraft, while Xerox does apply sales tax to the valuation of those copy machines, and does go through an analysis incorporating sales tax into each of the valuation methods. As stated later on in the Arbach case, there is, when similarly situated purchasers do not incur sales tax, as was the common carrier in Arbach, it is not included in the valuation of the aircraft. In addition, there's also the issue of sales tax, of the penalty. The penalty was incurred by John R. Lawson as a result of filing an untimely property statement. As the Assessor's Office noted, we were aware, we came to learn that their client had filed or had submitted the property statement in an untimely fashion. However, under Revenue and Tax Code 463 Subdivision C, if an assessee establishes to the satisfaction of the County Board of Equalization or the Assessment Appeals Board that the failure to file the property statement within the time required by Section 441 was due to reasonable cause and circumstances beyond the assessee's control and occurred notwithstanding the exercise of ordinary care in the absence of willful neglect, it may order the penalty abated. There is no evidence that John R. Lawson was neglectful in submitting this untimely property statement. They simply submitted it late. As soon as they realized that they submitted it late, they went ahead and they submitted the property statement to the Assessor's Office, and on top of that, the penalty incurred, which is, as the Assessor's Office has noted, is at 10%. And given that the aircraft is valued at nearly $5 million, $4,950,000, that as the Assessor's Office noted, that comes out to roughly $500,000 in penalty addition. Now, to that, Lawson's only paid the property tax on that penalty, but still, it's an excessive penalty for submitting an untimely property statement. Now, we understand that it's in the code that if you just file it untimely, there's a penalty that's attached to that. However, if the code didn't mean for the board to have discretion in situations where that penalty may be excessive, then it wouldn't have included Section 463 subdivision, I believe D it is. If the board has any questions as to any argument put forth by John R. Lawson. We do have our own accompanying exhibits. They, the majority go to to establishing the purchase price at $4,950,000, and also to indicate that the aircraft was in fact by agreement and in action taken delivery of outside of the state of California, pursuant to the purchase agreement is in Exhibit 5, and they have the flight record there following the purchase record having been sent out of state. Other than that, if the board has any questions, there is a John also quickly like to point out that they did incur nearly $500,000 in repairs to the aircraft, and so and that is also included in our exhibits as the last exhibit, Exhibit 10, an invoice where John Lawson incurred $533,370.95 in repair costs to the aircraft. And so we also asked the appeals board to consider that if the Blue Book value is what's used to assess the property, that the aircraft was not at the value of the aircraft was not the aircraft was not in a condition as a well functioning aircraft at Blue Book value, and so John R. Lawson had to incur additional costs in repairing the aircraft. But with that, I'm more than happy to take any questions that the board may have.
I do have, it's just a procedural matter. You presented this today, right?
Correct. Yes.
Mr. Austin, did your people have a chance to look at this or anything? Oh, okay, you've seen this, okay, I just want to make sure.
Except for the last page with the repair that Mr. Sanchez mentioned. If I could make a comment, if it's okay?
Well, we'll
Okay.
come back to you for comments on his, and then we're going to ask him for comments on yours. So
Thank you.
we'll be back to you. I just want to make sure you had the whole thing.
Yes, we do.
Okay.
Thank you.
Okay, all right, do we have any questions?
I have a question.
Yeah. I think you need to talk into the thing there.
You know, why was it late? What caused the filing late?
There was no negligence on behalf of John R. Lawson. It was an oversight. They simply forgot they were planning on challenging valuation, and so they got confused. We didn't receive it on our end or anything, so it wasn't through any willful neglect on their behalf.
You said the 10% penalty be changed to 10% of the assessed value. So you are saying that we are doing it on the total value, including the sales tax. So are you saying that the sales tax be excluded before they impose the 10% penalty?
Correct. Since it's based on the valuation, and we don't believe the sales tax should be included in the valuation to begin with. That is correct.
Okay. Question, Mike, is the repairs are allowed to be taken out of the assessed value?
First, we didn't even know about the repairs in the first place. And in second place, if we assessed it, revised assessment at the $4.9 million, that is taken in consideration as a purchase price. As you can remember, Trang discussed the Blue Book value at $5.8 million. And so if you technically look at that, then we recognized it by taking it from 5.8 million Blue Book value, which we assess everybody for, down to the 4.95 million. And so technically, we probably already looked at that, even though we didn't know about it.
So they haven't filed that so far? The repair?
Excuse me?
We haven't seen the repair bill.
We did not see it, and we didn't know about it until today.
Okay. Thank you.
Mr. Mejia, if I could
Sure.
Okay, the repair bills, that, if you look at it, it's, thank you. If you look at the repair bills, it's over a year, actually a year and 5 months after the subject's valuation date. The subject valuation date is of 1/1/2017. The repair bill was paid May 9, 2018. So it doesn't applicable, it's not applicable to the year in question. In addition, if I can direct you back to the assessor exhibit, it's indicated on their property statement that the condition is average and that there is no damage history on this aircraft, and that's under Exhibit A of the assessor exhibit. Thank you.
Thank you. Thank you. One more question, Mike. The applicant's address is in Fresno County, right? Or
I
is it
believe so,
Madera
yes.
County?
I believe so, yes.
Fresno, right? And the airplane sits in Merced County.
In Madera County at the Madera Airport, right, yes.
So which county we use for sales tax purposes? The
It would be the location of the aircraft, which
location of
is
the
this
property.
county.
Okay, thank you.
Do we have any more questions for,
Let's see, any more. So in the end, your conclusion is that you want this property value to be reduced to 4,417,000 rather than 4,950,000? Is that where we are?
Correct. That's the valuation based on the purchase price agreed to with the assessor's office minus the repair costs. And we also know that in the alternative, because we are aware that this was presented sort of at the end here, if the repairs are, or it's a discretionary thing, we're asking the board to consider. In the alternative, the $4,950,450,000 purchase price, we believe is a proper valuation.
Oh, okay. And by the way, the chips bag is not taxable.
any other questions? Okay. Normally, we let the assessor's office have a time for any additional comments they want to make, and then the applicant would have time for any additional comments. So everybody gets to speak their piece.
First, I'd like to say, Julio, do you have any questions of me or my staff?
No, I think we were able to kind of lay our positions out and both over email and letter and in the pre-settlement conference.
Okay, great. Yeah, we'd like to ask a couple questions. Trang, do you have any questions that you'd like to ask of the taxpayer? Mike, do you have any questions?
The only thing I would have is a response to the legal arguments that were made concerning two of the points, one the sales tax point, and the other is the 10% penalty point.
Okay.
So with that, I'll address some of the points set forth by counsel. The rule regarding sales tax as a component, it's a very long-standing rule. No court has ever affected it at all. As it pointed out in our presentation, it's in Section 110. It's in Rule 10B. It's in a very, I want to say, old 1977 Court of Appeal decision that's never been distinguished at all. It's very long-standing rules, so and no court case has ever changed it. The Auerbach case that's cited by counsel, the issue in that case was there a common carrier exception? Well, this is not a common carrier case, and so Auerbach's not applicable. The whole argument about trade levels, I would describe it as a red herring. Here, we have a trade level, the retail consumer level, that is not in dispute. It's all understood, and an applicant or assessee cannot just create his or her or its own trade level, saying that, oh, we are a similarly situated purchaser who avoided sales tax. So, but that's not a recognized trade level. Trade levels are, wholesale, retail, things like that. So there is just no authority for that proposition. So one thing too, for your notification, our office submitted a opinion letter to council's office actually a couple of months ago on this, and it's in the papers that were presented to you, so you and your council will have that. And those arguments are set forth in a little more lengthier, but I wanted to point that out to you. And then also going to the penalty aspect of it, Section 463C requires the assessee to establish that the failure was due to reasonable cause and circumstances beyond the assessee's control. Well, we have no evidence in the record whatsoever that there were circumstances beyond the control of the assessee, and because of those circumstances, things did not get done on time. So even counsel does not represent that in his statement, so it's not something that has any evidential proof. And if you have any questions, I'd be glad to answer.
Just a quick comment on the legal arguments. Arbach talked about Xerox. So the Arbach case talks about Xerox and specifically says that Xerox is not a case that resolves trade issues, trade level issues. Xerox is a case basically stands in for the proposition that property should be assessed at its proper trade level, and then it went in and analyzed the appropriateness of sales tax to the printers at the based on the different valuation methods, and so Arbach does mention Xerox in that it does limit it in that way. And the second thing on the Arbach case is that Arbach mentions common carriers, but the reasoning why the court did not include, said that sales tax cannot be included in evaluation was because similarly situated purchasers as the common carrier would not incur the sales tax. That's the reasoning there. And when they were doing that reasoning, Arbach even said, it didn't even really, I think counsel indicates that it was a common carrier case. There wasn't much substance as to figuring out whether that particular common carrier in the Arbach case was or was not a common carrier. They basically said that evidence has been established that it's a common carrier. It delved more into the sales tax issue and in the trade level issue. With that, I'm also willing to answer any questions if the board has any, but I believe that concludes everything on our end.
I don't see any further questions here, so
I have one additional question of the taxpayers represented, Julio. Julio, does Mr. John Lawson have any other airplanes?
I don't have any particular knowledge as to whether he currently has any more other airplanes. All I can say is I believe he may or may not have more airplanes, but I personally do not. I've only worked on this particular matter.
As a matter of fact, I looked this up this morning, and Mr. Lawson, it's John R. Lawson Rock and Oil Incorporated, he actually has 3 additional airplanes, okay? And he has filed business property statements on these airplanes since 2007. And so he's aware of the regulation, he's aware of the law. So I submit that that I don't see a reason why he did not file this particular return. That's all I have.
All right. No more questions? Okay, normally we take this under advisement, and then we, I believe we have come up with findings of fact on this also, isn't that correct?
The rules now provide that you can direct the parties to prepare the draft of the findings of fact.
Okay, so,
We recommend you do that.
okay, so they gave you a check.
I do have a deposit from the applicant for findings of facts.
Okay, and so in that case, our counsel normally provides the findings of fact, is that correct?
No, that is not correct.
Not correct, okay.
No, we agreed to a local rule a couple years ago now, maybe 3, maybe now. And now what we're going to do from now on, from whatever that day was, we prepare the findings of fact. What we need from you folks is a tentative value, and then we'll do a tentative findings of fact, okay? Assuming we prevail, and if the taxpayer prevails, then he or she is required to do a findings of fact. And that's what we're going to start doing as of now.
Okay, is that,
When that's done, the other party then has an opportunity to comment on the draft findings that have been prepared.
Yes.
okay,
And actually, it works to the taxpayer's financial advantage, because if I do it, we start billing them for all the time I spend working on it. And they won't have to pay the bill until we get to the final process.
yeah.
Right.
So, is, you understand, and,
Yeah,
Okay.
I think we got it.
okay, so, correct me if I'm wrong, but we're going to come up with a value. You're
Yes.
going to prepare a finding of facts,
Yes,
and then that is going to be distributed as a draft to both sides, and
Yes.
then we'll have to adopt it, a final, that's,
yes.
yeah.
Yeah, and we send all the drafts to your council.
Yeah.
And he can make comments.
Yeah, okay. Is that everybody on the same page now? Okay? Okay, good. All right. Well, I believe that concludes this portion of the hearing.
That concludes our portion, yes.
Yeah, okay,
Thank you.
thank you.
Thank you.
Thanks, everybody. Appreciate it. Thank you.
Okay, on my agenda, I have the next item as a hearing for Donald L. Burgess Jr., 17R024.
Yes, Mike Austin appearing for the Assessor's Office. In regards to Donald L. Burgess, as you can recall, last month, we, meaning Assessor's Office, needed additional 30 days to go out and inspect the property, review the property, and talk to the taxpayer and that type of stuff. We have done that, and we agree that there is some deferred maintenance on the property. We have lowered the value from what was enrolled. We have sent a stipulation of value to the taxpayer, and as of today, we have not received it back. And so we'd like to, again, postpone it for another 30 days so we can talk to the taxpayer and make sure that he gets the signed stipulation back to our office.
Okay, but it sounds like you think you have a value that you both can agree on, is that?
Yes, we
basically-
do. Yes, we do.
Okay. All right, does anybody have any other questions? No. If not, we have a motion.
I move that we postpone the hearing, this item number 17R024 for Burgess Donald L. Jr.
Seconded?
Okay, it's been moved and seconded to postpone for 30 days the hearing. All in favor, say aye.
Aye.
Opposed? Motion passes. Okay. Then we have a group of hearings that were all of a similar nature, which we have now just received. And these are on our agenda items 5C through 5I. And they've asked for a continuance to December 6th, 2018 on all of those items. They're all, I assume they're all in it is my understanding they're all in a cluster.
Yes,
Yeah.
they are. There are, I think, 6 or 7 fourplexes all in the same.
One cluster.
Yeah,
they're-
one area.
They're owned a little bit differently, which is why there's different ones here, but they're all in the same cluster.
Right.
Okay, Mr. Austin, what's your comment on the request for?
As a matter of fact, we agreed to the postponement to December 6, 2018 for roughly 60 days. He has, Mr. Jeff Radcliffe just sent us a new an appraisal. We are looking at it now, but the taxpayer wanted us to have some time to look at it, and so we mutually agreed to postpone it for 60 days. And so we'll be looking at it, and we'll get back to you. So please allow the postponement to December 6, 2018. The assessor's office agrees.
Have we got any issues with, time on this? Need a stipulation to waive time?
No, we do not, because it's a 17, and so it was filed last year, I believe, sometime in, I believe, like
So we're not
October.
bumping up against
We're not
the-
coming up on a 2-year, no.
Okay, all right. Any other questions? Anybody?
No? Okay, I make the motion that we move these items 17R044, 17R045, 17R046, 17R047, 17R048, 17R049, and 17R050 to December 6, 18.
The last one is for a different individual?
Yes,
That's his,
yeah,
that's
they're all
his,
in the same cluster.
That's
but
his brother-in-law.
One guy
We
owns,
don't have to do it separately?
yeah, that's his brother-in-law.
He
Oh.
identified the number, that's good.
yeah.
Yeah, okay. I second it then.
It's been moved and seconded to continue these items to December 6th. All in favor, say aye.
Aye.
All opposed? Motion passes. Okay, next item on the agenda, are actually two related items, Mammoth Mountain Ski Resort. We've discussed this in the past. Correct me if I'm wrong, Mr. Austin, but aren't we basically waiting for the other jurisdiction to come up with their value?
Yes.
And we're
Mono
a
County,
small portion of the thing, so
Yes.
we let them get theirs and then we do ours. So-
yeah, I talked to the attorney of record, as a matter of fact, yesterday, and he is still talking with Mono County, and we actually have talked to Barry Beck, the assessor of Mono County, and they're still in discussion stages, and so we'll postpone it another 60 days, see what happens, and next month we have a stipulation waive time on this account, and we'll probably postpone that another month to December, put them all on December 6th, and in December, we'll see what happens.
Yeah, okay. All right, any other questions? No. Entertain a motion to continue.
Okay, I make a motion to continue item number 14R083 to, and item number 15R045 to December 6, 2018.
I second that.
Okay, it's been moved and seconded to continue the Mammoth Mountain items to December 6th. All in favor, say aye. Aye. All opposed? Motion passes. Okay, item 6 is stipulation of assessed value. It looks like we don't have any of those cases this month. Okay, so item 7, non-hearing matters for discussion and direction. Anybody have anything the board needs to talk about?
We don't at this time.
Okay. Staff reports and/or agenda request?
Not at this time.
Okay. I believe we need to confer about the Lawson matter. So
Yes.
we'll adjourn to the other conference room and come back when we're done with our meeting. So,
Okay.
okay?
Sarah, could you notify me if and when the board comes back and has a valuation?
What time?
Thank you.
Yeah, we'll do it now. We'll see.
Okay.
And we'll see if we can do it in 15 minutes or if we're going to have to go do something else.
25,
Do
29.
you have someplace you got to be?
I just got to move my car.
Oh, okay. Yeah, go ahead and move your car.
Yeah, let's not, yeah, we don't want you to get in trouble. Yeah, that wouldn't be good.
Here's the new map.
Oh, okay, yeah. I want to see that.
This isn't individual wells, this is supply systems. Oh, wow. Green is, they don't have any hits, red is where they're having hits, look at that. Look at that. Oh, yeah, yeah. And of course, Fresno is dead center in this thing. Yeah, yeah, there's Fresno right there. Yeah, yeah, you can see, not every system has it, but there's 1, 2, 3, 4, 5, 6, 7, 7 out of 8. That's what I'm saying, it's just, and then you get out here in the middle of the, these where all the food processors are. It's 80, 90% of the wells.
Hey, thanks for showing me that, I appreciate that.
Yeah, and that, I don't know what the hell they're gonna do, because these food processors out here, they don't make enough money to put a $5 million treatment plant on it. They're out of business. That's what, then what these guys are.
That's what the problem's saying, yeah.
Yeah, I'm getting them and they're going, what do we do? I have no idea. I know. I mean, I said, other than, you can, like I said, you go back and tell the state,
That item.
Okay. All right, we're back in open session. It's 10:52, and I would entertain a motion to continue the case until the December meeting. Any comments?
I so move.
You so move?
I second it.
Okay, it's been moved and seconded to continue until the December 6th, isn't it? December 6th?
November.
I'm sorry, November, you're right, okay. We moved all the other ones to December.
Yes.
Okay, excuse me, we are going to continue to the November, is it 4th? Is it November 4th? November 1st. Continue to November 1st All in favor, say aye.
Aye.
All opposed? Motion passes. Okay, I entertain a motion to adjourn.
I move that we adjourn.
Seconded?
It's been moved and seconded that we adjourn. All in favor, say aye. Aye. All opposed? We're adjourned.
Thank you.
Sarah, I got the packet of information the taxpayer presented, Mr. Lawson's attorney presented today.
Yes,
I don't have whatever was submitted by the assessor.
I can provide that to you right
If you want to just, if you have a copy, that's great.
have one for you, yes.
Oh, okay, great.
give it to you and I totally meant to, and I apologize.
I'll come over there.